Good afternoon. Today is Monday, March 28th, 2022, and this is the Senate Judiciary and Public Safety Committee. Today's agenda includes one bill, Senate File 2673, which is the Senate's Public Safety Omnibus bill carried by Senator Limmer. This hearing will include a walkthrough of the bill and spreadsheet allowing our committee questions and discussions. No committee action on this bill or public testimony will be taken at this time. The DE amendment spreadsheet and bill summary were all posted last Friday afternoon, and copies are in your packets. Let's begin then with Senator Limmer and his opening remarks. Senator Limmer.
Thank you, Mr. Chairman and members. We have a lot to unpack today in this bill. Senate File 2673, I'd like to keep you focused on the delete everything amendment. This bill touches on all aspects of the criminal justice system. The courts, start to finish, youth intervention, criminal laws, sentencing guidelines, police, prosecutors, public defenders, judges, prisons, probation, and I think I've covered just about everything. Making our criminal justice system work in Minnesota is critical to keeping our communities safe. And that takes transparency, accountability, and it does take resources. To begin, youth intervention. Last year, we increased their budget by almost $600,000 per biennium, and this budget reflects an additional $3 million. The Youth Intervention Program Association is a proven system that requires a local match and greater accountability to the Department of Public Safety and legislature than other recently formed nonprofits that we keep hearing in the news these days. I am concerned about the accountability of public money given to nonprofit organizations, and there's been some recent stories about that very subject, and so I'm very cautious. And you can look at other news accounts. We've seen it where, let's see, KSTP, top news city approves millions more for violence interrupters amid questions of transparency and accountability. Alarmingly, in the last 2 years, there's been news stories about these violence interrupters working at nonprofits who've been tasked to work with law enforcement to de-escalate situations, who themselves, the members, are on record of violently harming other individuals. These certainly would raise concern with me, and I think with you, that when we task a nonprofit to do the work of the taxpayers and citizens, there must be strict accountability. Second area is violent crime. The headlines constantly barrage us with new violent crime stories. We hear about local reports, even from my neighbors and people who don't live in my neighborhood but have accounts as they travel around the metropolitan area. It's hard right now to find someone in our lives who has not been affected or have witnessed some type of serious crime just in the last few years. Our constituents are struggling with this. They expect a safe community, and we need to acknowledge their concern, and we need to grapple with it as well. Every crime has a ripple effect, either because someone has been violently injured, or because their car was stolen and they can't go to work, or because a petty criminal is emboldened to commit more crimes if there is insufficient reaction from our community. The question of punishment and deterrent is a critical issue that we have to recognize. Gangs seem to be taking over more and more of our streets in metropolitan areas, terrorizing entire neighborhoods. Oftentimes, gunfire is a repeated performance nearly every night, and killing innocent bystanders. Most often, children are the victims. They may be far away from the incident of the criminal act, but the stray bullets find their target. Drugs are pouring into the state at an alarming rate, and people are dying from fentanyl and overdoses nearly every single day. Drugs are pouring in. Despite that, we passed a fentanyl bill last year in the Senate. Strong bipartisan support, 62-5. But the House is not interested in it, has done absolutely nothing with it for 10 months. The House could take up that file, Senate File 1279, and pass it immediately, but they've chosen to let people be harmed and even dying from it instead. It's vitally important to curtail the fentanyl coming into our state. One of the ways to address the increase in violent crime is to have a more robust level of punishment for those who are committing the worst of the worst offenses, particularly those who use firearms in the commission of a crime, those who are habitual criminals that never seem to change their lifestyle or their ways. The question has to be asked, how many second chances should a person get before we remove them from the streets because of their antisocial criminal behavior that victimizes others? Third area that we'd like to address is the Minnesota sentencing guidelines. As you may remember, this is a group of unelected individuals. 8 of the 11 members are appointed by the governor, and they have proven over the past 3 years that they are more interested in treating criminals as victims and would prefer to use a one-size-fits-all probation cap system. It doesn't recognize proportionality or parity in that type of a system. This bill recognizes that an artificial probation cap does not reflect the sentences the legislature had previously allowed judges to hand out, which includes allowing judges to give longer probation periods for the most serious and violent offenders. Additionally, we believe that it's time to start confirming the members of the commission. The commission is going in a direction, perhaps some people would say the extreme allowance of their involvement on that commission, but they're going in directions that we've never quite heard before. So I put a bill together recently to allow the Senate to confirm those members on that commission. I've stated in the past that broad changes and sweeping reforms must be analyzed by those accountable to the public, those who are elected, rather than pushing through reforms by unelected members of the commission. Fourth area is law enforcement. As a state, we must absolutely offer encouragement to our law enforcement personnel as they begin to take early retirement and resignations rather than deal with some of the issues that they face locally with administrations in different cities. Despite a few isolated cases, law enforcement is an honorable profession, and we all must come together to bolster their numbers and once again attract high-quality candidates to protect the public and serve our citizens. The bill addresses many aspects of this equation: recruitment, education and training, equipment, retention, and there are also other provisions pertaining that are being tracked by separate bills in other appropriate jurisdictions. At its heart, law enforcement is a function of local government, and we must absolutely expect local control as well as local transparency so that our privacy rights are not trampled by a more bureaucratic, centralized form of statewide law enforcement system that may become overly burdened with bureaucracy and cannot make changes to reflect local needs of local communities. In this bill, we're trying to correct that balance. How do we best help local communities with law enforcement recruitment and training without losing local control and privacy rights? The other area that we must address is the role of prosecutors. As more stories of violent crimes with lengthy criminal records come to light, constituents find out that a prosecutor agreed to another diversion program or yet another plea bargain or a decision to not prosecute or seek a weak, timid sentence, and the public's trust is shaken. This is true now during a violent crime wave of murders and aggravated assaults and carjackings, but the fact that people on the other side of the political discussion are also found protesting at a prosecutor's home as well. And that means to me that this is not a one-sided observation. It's a concern of both sides of the political aisle. We must have better methods of transparency that people who elect county attorneys understand the decisions their prosecutors are making and what policies they have in place about what categories of crime that they may not set bail on or categories that they will not prosecute. That's vitally important for our citizens to know what kind of role and job our prosecutors are doing. Deciding to wholesale reject all prosecutions in certain categories of crime does not sound like they're using proper discretion, but using a wholesale version of that discretion. Some of the most serious criminals and terrorists in the country have been discovered from some low-level offenses. I can only think right now, the one that comes to mind is the Oklahoma City bomber who had a traffic stop because of a minor vehicle infraction. And yet Timothy McVeigh was arrested during that time and eventually prosecuted. This bill allows anyone to investigate for themselves what their prosecutors decide when they dismiss charges, and that it's an extremely important tool for them to decide later at the polls to who to vote for. Judges. Similar to prosecutors, judges have been agreeing to plea bargains or handing out downward departures in sentencing at a higher and higher rate. That too is beginning to cause questions in our public's eye. This bill provides our constituents a simple method to investigate the decisions of judges that they would vote on with the creation of a searchable database. Some opponents to a database argue that it's duplicative, but it is hard to find. So I would argue it is not duplicative, and we should make it as easy as possible for citizens to follow the decisions of a judge. MNCIS is being replaced by MCRO now. It's a criminal justice reporting system. These are both systems that are run by the judicial branch. It's their right as a third branch of government to have that function. But the one thing that's missing is that's function of the third branch of government. The legislature does not have any control of it. And they could decide tomorrow that they don't want to have that much public access if they decided to do that. I think it's important for us to preserve that record. Additionally, judges seem to be departing downward in sentencing more and more, as I said, and we disagree with some of those decisions in cases involving habitual offenders, those who are most violent, those who might use firearms in the commission of a crime. This bill addresses that with some mandatory minimum sentences and other changes that places our penalty level, meaning the penalty level the legislature has imposed in state statute, where we believe it should be. And that truly is our responsibility under the Constitution. However, even with some frustration about judges, we also recognize they do have a hard job to do as they fulfill their constitutional responsibilities. In 2021, we tried to give them a pay increase in both years of the biennium, Other players at the negotiating table were not terribly interested in that, so we're back again. Last year, we gave them an increase in the first year of the biennium, but unlike other government employees, they will receive nothing in the second year. The Judicial Branch has been a good fiscal partner over the past decade. They've had some lean years where their budgets have been frozen. And this increase that you will see later recognizes the previous sacrifice that they made and hopefully bring the best and keep the best of the best to the bench. Public defenders. Public defenders nearly went on a strike just 1 week ago. And quite honestly, they may have had just cause. They've been underfunded a lot over the past dozen years, the same way the judges and court staff have. And unfortunately, we're paying the price now, and it's difficult to hire public defenders, especially in rural Minnesota. Wherever you go, they are paid sometimes tens of thousands of dollars less than their prosecutorial counterparts. To have a constitutionally responsible criminal justice system, we must have public defenders standing up for indigent clients in Minnesota, and the appropriation in this bill will provide resources for more attorneys across the state. This budget will provide them with significant funding, probably an amount that will exceed how quickly they can hire new attorneys, but we remain hopeful that weighted caseloads will go down quickly as new hires are brought on board. In the area of probation, as some know, the vast majority of Minnesotans who are sentenced end up on probation rather than a criminal incarceration in prison. Sometimes this is appropriate for first-time offenders or those who need an immediate second chance to straighten them out, especially those that did not commit felonies, or those who commit common petty property crimes or personal drug use. What a lot of Minnesotans may not realize is that our state is one of the lowest per capita incarceration rates in the country, if not the lowest right now. There's only about 7,500 inmates in our prison system at the beginning of 2022. As a state, we decided over 40 years ago that we would rather invest our resources in probation in the community where they come from so that people with lower level offenses did not hurt someone, those who did not hurt someone in the commission of their crime could live within their own community with a support system that would hopefully bring them back to a straight and narrow, responsible citizen path, or to receive drug treatment in their local area. We have 3 delivery systems of probation, and believe this is an issue of local control that I especially prefer. Local counties have the best grasp on what communities are like. They work closely with police, prosecutors, judges, other criminal justice partners in their respective regions. We should keep it that way. The same concern about a one-size-fits-all system of prosecutors not charging crimes, or a Minnesota Sentencing Guidelines Commission deciding that all probation should be capped no matter what the offense or criminal history, also exists with probation. It would be a similar disaster to bring all probation decisions and management to a governing board somewhere within a central governing body such as the Department of Corrections. A number of years ago, however, we as a state did agree to take on part of the responsibility for paying for probation and community supervision. It's in our law, and yet it's been greatly ignored. This bill acknowledges that and gets Minnesota community probation officer counties to 50% of their funding responsibilities, and does about the same for the Minnesota Community Corrections Act counties as well. In the area of prisons, as many have observed, Minnesota prison is reserved for the most violent offenders, some call it the worst of the worst, and most habitual offenders. Our model of probation does not work if people never face consequences for failure to abide by rules in their community. I believe probation must be robust. That's why we need money to make it work. We must have a way to stop thugs assaulting elderly people, to stop carjacking mothers while children are still in vehicles, and to stop robberies of any and all kinds. We must have a way to effectively punish habitual scofflaws who escalate their crimes. And we must have a way to get gangs, murderers, drug kingpins isolated from the public and for sufficient amounts of time, hopefully that they learn their lesson. Well, last year, Governor Walz recommended something called the MRRA. It's one of their proposals this year. The MRRA, which sounds interesting, but actually reduces the amount of prison time that a person could earn from good time from 2/3 to 1/2 of their imposed sentence. When I bring that up to my citizens, they get really concerned, especially with the backdrop of increased crime, increased violent crime, carjacks. And I just talked to one person at my church on Sunday. They knew 2 families that had their car carjacked just in the last week. And both of them are living in the suburbs, and that's where the crime occurred. So it's not a crime that's isolated to the urban core like some people think. Oftentimes, the people that commit these crimes are not, they do not achieve a criminal sentence either. After all, if prosecutors and judges are accepting plea deals for lesser crimes and shorter sentences, we must have a way to bring balance to that. We just simply cannot be soft on crime during this critical era when crime is on the rise. Minnesotans, I believe, are looking to restore faith in the criminal justice system, which is, I think, lacking right now. We must have accountability for our state. I think we have to bring accountability to those that are breaking the law. If their behavior is so antisocial and they're victimizing other citizens, they should be isolated and put in a prison. Now, please, let's not forget, this is a supplemental budget year. When combined with provisions from last year, for example, in 2021, we provided an increase in over 22% to civil legal services across the next 4 years. I think that's a Minnesota state record. That we've never increased it that much in such a short period of time. We're fully addressing needs of the courts and all users of the system to the extent that we can, as fairly as possible, using finite resources and with inflation expected to continue to rise. A lot of this bill that you're going to see it will be familiar. We've incorporated many things already heard this session, and there are many provisions that I think we all agree on. And there are some that just is going to attract a philosophical difference. And there are others not included in the bill that don't really seem ready for presentation quite yet. New provisions in the budget bill, there are, as I said, left over from last year. Senate File 635 addresses the point of the Sentencing Guidelines Commission raised that there is no penalty actually listed in statute for murder of an unborn child. This is not to be confused with an abortion issue. This is strictly the murder of an unborn child. This bill is in our Omnibus bill. Also, from late 2020 through last session, we discussed the probation cap at length in the form of Senate File 870. a provision that ensures those who commit violent crimes against an innocent and oftentimes vulnerable citizen, which might include arson, robbery, aggravated assaults, are not presumptively given a 5-year probation cap. That's recognizing these types of crimes that are different than others that should not, in my opinion, should not get an automatic 5-year cap. We also recognized a higher dollar amount in the Senate for VSETs. That's the Violent Crime Enhancement Team last year. Senator Rosen and I are back with an increase again to try to get at illicit drugs, fentanyl, and guns pouring across our borders and literally killing our citizens. There's major differences between bills we've previously heard and what is before us now. Most of the provisions this year we included are the same as when we heard them in committee, and we amended several of them already. And those amendments are reflected here, but there are a few provisions with some significant changes that I'd like to point out. For the mandatory minimum sentence for the use of firearms in the commission of a crime, it's a statute that already exists in Minnesota Statute 609.11. We are removing a prosecutor and judge's ability to waive that sentence for first-time offenders. The perpetrator and the accomplice who is, and I want to underline this, who's aware of the firearm. The accomplice must be aware of the firearm. We are leaving in place some discretion for those cases when the accomplice did not know there was a firearm at all, and we're leaving discretion for other dangerous weapons so the prosecutor and judge can weigh the individual circumstance. You may recall Senator Gazelka had a similar bill, but he recognized not only a gun in the commission of a crime, but other objects that could be used as a deadly weapon. Those other weapons I would rather leave in the discretion of a judge. What I think we need to do is focus on the use of a gun in the commission of a crime. For the provisions of stealing a car and then going on a crime spree, we've left the list of crimes in place, but extended the time period between the theft of the car and the date of the commission of the crime to 7 days. And I'm open. If the committee wants to move that further, I'd be open to it. I think 7 is a good balance, but I'll leave it up to the committee to discuss and come to that conclusion. For the provision of emergency management coming from Senator Weber's Senate File 534, we've worked with Department of Public Safety, the advocates on language that is agreeable to them for application and reimbursement. That covers most of the highlights of this bill, and I'm going to turn it over to Mr. Turner to walk us through the spreadsheet now. And then I believe Mr. Backus will walk us through the policy side of the bill.
Thank you, Senator Limmer, for that. Mr. Turner.
Yes, Mr. Chairman and members, thank you. I'm going to be going over the spreadsheet titled Senate File 2673, Supplemental Budget, Chairman's Recommendations, if you want to follow along. We'll start with the Supreme Court. Line 3, Judge and Employee Compensation. Chairman Limmer recommends a 6% increase. That's an appropriation in 23 of $2.3 million with straight tails. Then we move to Court of Appeals, line 9, again, Judge and Employee Compensation. Chairman recommends a 6% increase, $621,000 in 23 with straight tails. District Courts, once again, Judge and Employee Compensation, 6% increase, $14.8 million with straight tails. We move down to line 21, Public Defender, increased salary and staff, fiscal year 23 appropriation of $50 million with straight tails. Under sentencing guidelines, the bill has 3 provisions with cost. The first is on line 27, the publicly searchable sentencing database, Senate File 3356. That costs $265,000 in '23, $289,000 in '24, and $87,000 in '25. On line 28, we have the Guidelines Commission meetings recorded and publicly available provision. That comes with a one-time cost of $4,000 in '23. And then Senate File 2841, County Attorney reason for dismissing felony charges, the report required by the guidelines. It's a '23 cost of $569,000 with tails of $145 each year. Then we move to the Department of Corrections. Lines 37 to 43 are 7 sentencing bills with bed costs. I'll list them here. Senate File 2844, fleeing a police officer felony enhancement. Senate File 2843, car theft used in a subsequent crime. Senate File 2573, carjacking. Senate File 2673, mandatory minimum firearms only. Senate File 2850, increasing the term of imprisonment from 2/3 to 3/4. Senate File 3487, organized retail theft. And Senate File 3224, aggravated and consecutive sentences. As you can see, if you're following along, on line 44, I've totaled those costs, and in aggregate, those bed costs for fiscal year '23 come to $2,532,000. For '24, it's $8,552,000, and for '25, it's $15,692,000. Then finally, under incarceration and pre-release services in the department, we have Senate File 2893 on line 46, interstate transport reimbursement to counties, cost of $250,000 in '23 with ongoing tails. Then we move down to DOC, Community Supervision and Post-Release Services. These are the increases to the 3 probation delivery systems. On line 52 is the Community Corrections Act subsidy increase of $16,250,000 ongoing. Line 53 is the County Probation Officer reimbursement, $5 million ongoing. And on line 54 is DOC Supervision Services, $3,750,000 ongoing. We move to page 2 of the spreadsheet, Department of Public Safety. There's a list of Department of Public Safety grants. Starting on line 62, Senate File 2848, Police Recruitment Advertising Campaign, $1 million one time. Senate File 2847, Pathways to Policing, $1 million ongoing. Senate File 2890, Ramsey County Gunfire Detection System, $2 million one time. Senate File 2934, Mental Health Treatment, Law Enforcement, and First Responders, $1 million ongoing. Senate File 2796, VSET grants, statewide, $2.5 million ongoing. Senate File 534, Emergency Management Readiness Grants, $3 million ongoing. Senate File 2989, Youth Intervention Programs, $3 million ongoing. Senate File 3042, School Safety Specialists, 2 new specialists, $250,000 ongoing. Senate File 3332, Prosecutor Training, $100,000 ongoing. Senate File 2889, Ramsey County Sheriff Prevention Grant, $3 million one time. Senate File 2892, Body Cameras for Local Law Enforcement, $5 million ongoing. Senate File 2891, Use of Force Training Reimbursement, $2,625,000 one time. That will purchase 10,500 trainings, one for each policeman, at $250,000 each. Then Senate File 2846, Police Education Expenses Reimbursement, 500 reimbursements at $5,000 each, comes to $2.5 million ongoing. Senate File 3073, Police Recruitment Bonuses, 2,000 bonuses at $10,000 each, comes to $20 million one time. Senate File 3223, Police Bonuses for Exemplary Service, 250 bonuses at $10,000 each, $2.5 million ongoing. Senate File 3328, Police Retention Bonus Program, all officers, $47 million one time. Senate File 4134, Minsky Law Enforcement Skills Programs, $5 million one time. And finally, Senate File 3594, Shelter Services for Racially Diverse Youth, $210,000 one time. The bill has two provisions which have general fund revenue adjustments in them. The first is on line 86, Senate File 3029, the fee elimination for copies of uncertified court documents. It is a general fund cost in 23 of $362,000 with cost of $395,000 in 24 and subsequent years. And finally, Senate File 2857, the Minnesota Family Resiliency Partnership increased fee share, or actually it's a fee reallocation. General fund cost of $1,027,000 in 23, $1,120,000 in 24 and subsequent years. And that, Mr. Chairman, comes to our total net spending on line 91, fiscal year 2023 of $199,422,000, and for the 24-25 tails of $255,596,000. And now I'm going to move on to the bill.
Certainly.
Or do you want to take questions on spread? I think.
Why don't you
Bill first.
continue, and then after you're done, Mr. Turner will turn it over to Mr. Backus.
Yeah. Mr. Chairman and members, I'm going to do Article 1, and then Mr. Backus will do Articles 2 and 3. Real quick, Article 1, Sections 1 to 8 are the uncodified riders that implement the spreadsheet. And then the codified language starts on page 17 with Section 9. I'll quickly run through. Section 1 is just the appropriation mechanics for the bill. Sections 2 to 4 are the appropriations for the courts, the salary increases. Section 5 is public defender appropriation. Section 6 is sentencing guidelines. It has the three provisions in the spreadsheet: searchable public database, recordings of commission meetings, and reports on dismissals by prosecutors. Section 7 is Department of Corrections. It has the rider for the interstate adult offender transportation reimbursement, and then also the riders for the three probation delivery system increases on page 3, CCA, CPO, and DOC. Then it goes into the report that's required on how that money is spent. Section 8 is the public safety grant program, starting on on page 4. Paragraph A is promoting the police recruitment advertising campaign. Paragraph B is pathway to policing. C is gunshot detection. D, first responders for mental health, or the Heroes Helping Heroes program. E is the VSET rider. F is the emergency management grants. Already been through this. G is youth intervention. H, school safety center. I, prosecutorial training. J is the Ramsey County Sheriff Violent Crime Initiative. K is the body cam appropriation. The body cam has codified language later in the article under section 12. L is the use of force training grant. M, peace officer education reimbursement grant. N is the bonuses for newly hired police officers. I'm on page 13 right now. Moving on to 14. O is the exemplary service bonuses program, Senate File 3223. P is the bonus payments to all police officers. Paragraph Q is the Minsky Police Officer Skills Training Program, on page 16 now. And then paragraph R is racially diverse youth. We've already spoken about that. And that's the final grant program. Then paragraph S is a standard OJP rider concerning administrative costs for these grant programs. Then we start the codified language in Article 1, Section 9, Senate File 3356, Senator Cran's publicly searchable database. And on Section 10, we have Senator Matthews, Senate File 3752, on commission meetings being recorded and publicly available. Section 11 is Senator Limmer's sentencing guidelines report on county attorney case dismissals. Section 12 is the codified language on body cameras. Section 13 is the first half of the fee reallocation for the Minnesota Family Resiliency Partnership. It's regarding the divorce filing fee. Section 14 is Senator Latz's Senate File 3029, fee elimination for copies of uncertified court documents. Section 15 is the county attorney reporting of criminal charges and cases dismissed language. Section 16 is the second half of Senator Housley's Minnesota Family Resiliency Partnership fee. This has to do with the marriage license fee reallocation. And finally, Section 17 is the Peace Officer Bonus Program for Exemplary Service codified language. That, Mr. Chairman, is Article 1. And the Mayor, I'll turn over Article 2 to Mr. Backus.
Thank you, Mr. Burr. Appreciate that. Mr. Backus?
Thank you, Mr. Chair, members. So just a couple things to point out. You probably already know this, but there's a detailed summary in your packet, which has the original bill numbers for each provision in case you're curious where things came from. Also, as Senator Limmer mentioned, in terms of all the non-rider Article 1 provisions and then Articles 2 and 3, I mean, basically, these are all language from bills we've heard either in two cases from last year, but Senator Limmer also mentioned that, so there aren't really any changes. There are a few changes, substantive changes, that I'll mention as I go along, just to make sure you're all aware of that. And of course, we took the most recent versions of any of the bills we included, if they were amended in this committee, or in the case of a couple bills, if they were amended in other committees. And since you've heard all these bills fairly recently, I'll try to be fairly brief. So then Article 2 begins on page 25 of the Delete Everything Amendment. It's entitled Criminal Law and Sentencing Changes. Sections 1 and 2 come from Senator Limmer's retail theft bill. They're basically conforming changes, no changes there. Section 3 is from Senator Coleman's bill on fleeing a peace officer. This is just the provision that requires the DPS to revoke the driver's license for 4 years of a person convicted of the new crime. Sections 4, 8, 9, and 10 are from Senator Jasinski's bill, which increases the term of imprisonment period from 2/3 of the sentence to 3/4 of the sentence. The effective date was tweaked just a little there. The original effective date was August 1 for persons sentenced on or after that date. We changed that to persons who commit crimes on or after that date, which is a little more standard. Next come the Senator Eichhorn provisions, sections 5, 6, 13, and 20. These provisions, as Senator Limmer mentioned, were from last year. The committee passed it, went to the floor, came back via Rule 47. Basically, these correct a gap in law which currently exists with the first-degree murder of an unborn child crime. The sentencing guidelines pointed this out to us, and then this basically resolves the issue, provides for specifies what the term of imprisonment will be for this offense, and it resolves the issue by basically taking the comparable provisions from the regular first-degree murder crime and applies it to the comparable provisions in the first-degree murder of an unborn child crime. Section 7 is Senator Limmer's bill on the Sentencing Guideline Commission requiring confirmation. There was a slight change in the State Government Committee just to correct what was essentially an error in the original bill, so that's in here. Sections 11, 12, and 27 are for Senator Osmick's bill. This is the bill Senator Limmer mentioned where it provides for higher statutory maximum penalties for car thefts in which the offender then uses the stolen car in furtherance of a crime of violence. The main change here is the change from 72 hours to 7 days. There are a couple of other minor changes. The original bill specified that it had to be in furtherance of a felony crime of violence. However, that really wasn't the intent of the bill because the definition of crime of violence had non-felonies in it as well. So we clarified that. Again, that's more conforming. And then in a couple of provisions, including this one, certain definitions, for example, the crime of violence, I added the new carjacking crime, which is also here, which is basically a conforming change, but technically that's new for you. That takes us to the next four sections. Sections 14 to 17 were from Senator Newman's bill. This is the bill that amended the statutory provision which provided for enhanced sentences for third-time violent offenders or for career criminals, those with 5 or more prior felonies. And the provisions basically convert the permissive sentence to a mandatory sentence. One significant change here is the original bill had a provision whereby these offenders would serve 100% of their announced sentence in prison. That provision's been deleted, so they would serve the same proportion as other offenders would. As of now, that would be 2/3, but the bill would make that 3/4 because it changes all of the terms of imprisonments. Sections 18 and 19, Senator Limmer mentioned this. This is the change to the 609-11 mandatory sentence, which is the sentence for offenders who commit specified violent crimes with either dangerous weapons or with firearms. This has been changed, as Senator Limmer mentioned, so that a judge can waive the mandatory sentence essentially for a first-time offender where the predicate for the sentence is that the accomplice possessed a weapon. So as long as it's a first-time offense and the offender didn't know that the accomplice possessed the weapon, a judge would be able to waive the sentence. Section 21 is the bill that Senator Limmer mentioned. It has to do with stays of sentence for certain felony offenses. This is the bill from last year, Senate File 870. Just for some background, the statutory provision provides that when a judge stays a felony sentence and provides for the maximum term of probation, under statute, it's either 4 years or the statutory maximum for the sentence, whichever is longer. The guidelines in 2020 changed that, so it would essentially be 5 years or the statutory maximum sentence, whichever is less. And a judge could go beyond that if the judge essentially departed. But this provision would say that that cap from the Guidelines Commission doesn't apply to the offenses listed in the section. Section 22 is one half of Senator Westrum's bill from last Friday. It's the Section 2 provision. It doesn't include the Section 1 provision, which is the Bill of Rights, the Guardian Bill of Rights. That provision is not included, but this provision expands the criminal abuse of the vulnerable adult crime in certain instances. Section 23 is Senator Gazelka's bill on carjacking, creates a new standalone offense, provides for the stat max, which is essentially a bit higher than the corresponding stat max would be for what is currently a robbery crime, and would imply mandatory minimum sentences. Section 24 is Senator Coleman's bill, the heart of that bill at least, where it creates a new felony, a 4-year felony for fleeing a peace officer in a culpably negligent manner. Sections 25 and 33 make conforming changes related to that section I just mentioned. Section 26 is Senator Limmer's bill, basically provides a cross-reference to the new organized retail theft crime, which I'll get to next. And that provision is Section 28. It establishes this crime of organized retail theft. Again, no changes to any of these unless I mention. 29 and 30 are also from the same bill. It amends the identity theft crime to allow financial institutions to release certain specified information for prosecution of identity theft crimes. This language is slightly different. It picks up the change in the Civil Law Committee relating to the data provision, which was actually discussed in this committee. So it's the most up-to-date language. Sections 31 and 32 are also from the retail theft bill. It amends the 4th and 3rd degree burglary crimes to include situations where a person steals essentially from a building that's open to the public. Section 34 amends the law regarding search warrants and how long they're valid, and provides that search warrants on financial institutions are valid for 30 days. Section 35 is Senator Matthews' bill requiring law enforcement reporting on carjacking. This has been changed just slightly to make it more compatible with Senator Gazelka's bill, uses the same definition, things like that. Section 36 is from Senator Senjum's bill. It implements a pilot project intended to determine the efficacy of oral fluid roadside testing to determine the presence of controlled substances or intoxicating substances for DWI cases. And then Section 37 is Senator Gazelka's reviser's instruction relating to the new carjacking crime. This also was expanded just a little bit. We added a cross-reference to 609.11, which really should have been in the reviser's instruction originally, but I caught it just recently. Takes us to Article 3, which is entitled Driving While Impaired, Search Warrant Changes. These are all from Senator Senjum's bill. Basically, it broadens the definition of what a search warrant would be to include search warrants from adjacent states for DWI blood draws. And Mr. Chair and members, that's the entire rest of the bill.
Thank you, Mr. Backus. Senator Limmer, before we kick it off, do you have any other comments you want to make before we start committee discussion?
Mr. Chairman, I really do not. I think my comments earlier covered the intent of the bill and a brief description. Certainly, these are the times to get into a little bit more of the nitty-gritty, of course. But I think the concept I think we want to imply by a bill like this is that we are very much focused on victims. We're focused on hoping to stop criminal behavior. I believe some of our judicial partners have become a little lax, and we're reminding them that they have a duty before the public and their responsibility to the Constitution, that the government's purpose of even being is the safety of our citizens. And with that in mind, we'll open it up, Mr. Chair.
Thank you, Senator Limmer. So on my list, I have Senator Ingebrigtsen.
Thank you, Mr. Chair, and Senator Limmer, especially for bringing this, what I think a fantastic answer to what's going on in our state with regards to something we don't talk a whole lot about, and that's victims and the public safety. And actually, it's right in the title of our committee. For far too long, and I would say over the last 2 to 3 years, we've been forever seeing an increase in crime and not only in the cities, the 2 major cities in our state, but also now it's creeping out into the suburbs. And this bill, I think, is something that is going to help an awful lot. Mr. Chair, Chair Limmer, you mentioned the amount of money that was spent last year was was one of the biggest bills that you've ever introduced and dealt with. And this is I think, a tremendous supplemental to getting back to what one of our main purposes in government is the public safety. You've got crime prevention stuff in this bill. You've got police initiatives, police bonuses. Who would have ever thought that we would have to spend our precious dollars on trying to retain and keep police officers on the street? But that's what it's come down to. And I'm really sad to have to even talk about such a thing. But nevertheless, it's happening. And I've been very loud about previous discussions about what to do with police. And that now has turned totally around on those that are, or those that have at one time talked about cutting back on public safety, and now they're scrambling like the Dickens, if you will, to get back on track because of the rising crime. And it just tires me and sickens me when I look at the news every night, and then I see those little girls that have been shot innocently just by stray bullets alone. With all this gang activity and stuff that's going on, it's just horrible. But in your bill, you've got many areas that you're addressing that with the youth intervention programs. We have to still try and intervene with the youth when they're young and see if we can't, get them going in the right direction. Unfortunately, we have to have school safety specialists, but you have dollars in here for that, which is good. Ramsey County's got some crime prevention grants, body cameras for local law enforcement. That's been talked about for a long time, Mr. Chair and members, and there's a lot of departments out there that can't afford body cameras. This is addressing that very issue that came out of the committee that we had a year ago with regards to police and police handling of calls. We have money in here for de-escalation. There's been a lot of talk about that, more training for that, and also for the skills programs where if you're going to require them to wear this type of equipment, well, we need to train these young folks before they actually hit the road. So that, along with funding the judiciary, and I know the courts and public defenders have been underfunded, and Senator, you've addressed it in this bill and done I think a marvelous job moving forward. I'm very proud to be part of this, not only this committee, but this body, but very proud to be part and be a co-author on this bill. And I think this is just a start. Unfortunately, it's just a start, but there's some ongoing funding here that you put in here that will help address crime in the future, and hopefully we can turn this around in our community. The community that I'm talking about is 130 miles from where I live, and it's just like it's been just kind of turned upside down. And it's a beautiful little community. I've lived here for 16 years now, half-time. And I've learned to like the Twin City area, but I'm telling you right now, there's an awful lot of folks that just don't want to come here, and that is just unheard of, and that's unconscionable to even hear that here in the Midwest. So this is going to help, at least, I think, to get things on track, get other elected officials to be responsible for what they're elected to do. And again, I thank you very much for this initiative. I think it's a wonderful bill. It probably isn't enough, but it's a very significant step in the right direction. Thank you, Mr. Senator.
Thank you, Senator Ingebrigtsen. Senator Latz. Senator Pappas.
Thank you, Mr. Chairman. I believe I had my hand up first.
Very good.
Excuse
Please
me.
proceed.
Thank you, Mr. Chairman. Senator Limmer, I do think that the public defender provision in here to adequately fund public defenders is long overdue. So I'm very happy to see that. But I have to say, with the rest of the bill, I feel like there's really a lack of balance. And let me give you just one example. And I know Senator Ingebrigtsen mentioned this, but he didn't mention the dollar amounts. So I'm looking at basically youth prevention, and we know we've had a lot of issues with youth in terms of criminal actions. Youth prevention, $3,210,000. Now, maybe I missed another provision in there, but that's all I can see at an early glance. Yet, if I add up how much is in this bill for police bonuses, it's almost $70 million. That just seems to me to lack quite a bit of balance, Senator Limmer.
Thank you, Senator Pappas. Is that you finished with that?
I'm finished for now.
All right, thank you. Senator Latz.
Thank you, Mr. Chairman, and I share Senator Pappas's thoughts on this. There are some good things in this bill that I think we can find bipartisan agreement on, that not only the public defender funding, but other provisions, some of the policy changes in there, which I think are helpful. But it's not only a lack of balance, but I think part of this is a lack of just proven effectiveness that's in here and a disproportionate funding. We've got, I mean, right out of the gate, Senator Limmer talked about the youth intervention of $3 million and how it was a proven program, and that's an argument in favor of supporting it, which I totally agree with. Although when we asked them, you know, how much they'd really be able to use to extend their reach to what they think they could do right now, they said $10 million. So when we've got a bill that's so heavily loaded toward funding for police, but in the bill of $199 million, we couldn't find an additional $7 million to fund youth intervention. That seems like the bill is lacking in balance there, and I think we can do a better job with that. The other piece about that is that most of that, a lot of that money, I should say, goes toward the Department of Corrections to pay for the increased costs of incarcerations relating to mandatory minimum sentences or penalties here, which is rooted, at least in part, I think, in a fallacy that's been perpetuated by the proponents of these ideas, which is that our judges are weak on sentencing and our prosecutors are weak on prosecution. I don't buy it, and I don't see it. It's easy to cherry pick individual cases and say there should have been a different sentence here or there, or a crime should have been charged or handled differently, or a plea bargain was not appropriately handled. But when I think you look overall, you've got a pretty well-balanced criminal justice system in terms of prosecution and sentencing, which is in accordance with the sentencing guidelines, but still reflects the need to have some discretion and to account for individual circumstances, which is why we have the system set up that way, and we don't have the legislature hearing every criminal sentence that comes up in the state. But there's almost nothing here. Well, I'll back up one step. Those mandatory minimum sentences, when I asked repeatedly for data that said that that was an effective way to prevent crime from occurring, I got no response. The proponents of those bills, they sat here in the committee and they could not give us any statistical citation, studies or anything like that that said those mandatory minimum sentences prevent crime. The only response I got was, all we need is common sense. Okay, so I agree. If you take a criminal and you put that criminal behind bars, the criminal is unlikely to commit new crimes while behind bars. Okay, we can all agree on that. And there are some people that simply that's where they ought to be because they can't behave themselves in any other way. So we'll find common ground there. But there was an awful lot of talk about deterrence. You know, if they know that they're going to go away for 3 years, they're less likely to commit the crime. Well, there isn't any data to back that up, but there is data to back up the proposition that if they're more likely to get caught, that's what's going to deter them. And all you have to do is look at the United States Department of Justice and their Institute for Justice data. Lots of studies have proven that. And that depends not only on law enforcement numbers, but also on community trust, the willingness of a community to participate in solving the crimes. And for that, they need to be willing to share information that they have with local law enforcement. We need some funds in this bill that's going to help rebuild community trust. That includes reform and accountability measures to rein in the officers that are creating a lot of that distrust in the community. And I'm not painting with a broad brush here, but we know in some communities, which seem to be the favorite targets of some members on this committee, that there are certain groups of officers that have contributed enormously to that distrust. So even the communities that are most frequently victimized aren't willing to go to the cops to try to solve the crimes, because they don't trust the cops. There's not any money in here that's going to help rebuild that community trust, that information that will help solve crimes. So I think we need to take a better look at that. There was a reference during Senator Limmer's presentation that hearkened back to what we'd heard earlier during committee proceedings. Yes, you can get some big arrests out of traffic stops. The Oklahoma City bomber was one example. And that's true that you can. But the data shows that maybe 1 or 2% of traffic stops are going to lead to arrests for more serious offenses, to finding the contraband in the vehicle or finding someone who's got a warrant out for their arrest that's going to, that's something more than a non-appearance warrant. But in the meantime, while you're getting a 1 or 2% success rate there, you're violating the civil rights of 98 or 99% of Minnesotans by using essentially pretextual reasons to make stops. And let's be clear, because I was on this last time we heard this too. But once again, the broad brush that's been painted by the proponents of this bill there are some county attorneys, one in particular, we all know who is being referenced here, their claim is stopping to prosecute broad category of crimes. And I corrected the record on that last time this came up, and still we have that fallacy perpetuated here in front of committee. The Ramsey County attorney did not say that he would not prosecute all felony crimes. What he said was he would not prosecute felony crimes that arose from non-safety related traffic stops, like equipment violations or stuff hanging from the rear view mirror, things which are frequently used as pretext, meaning to stop vehicles in the hope that they're going to find something else. And that was used as a disincentive for police officers to engage in those pretextual stops. If they engaged in safety-related traffic stops, like speeding or something like that, or erratic driving, cutting off other drivers, tailgating even, those kind of things, traveling too close, following too closely, those are safety-related, and those would still be perfectly acceptable stops. And if there was contraband that was found as a result of those and felony prosecution available to that, the county attorney was going to continue to prosecute those. So let's at least be honest about what we're saying in terms of supporting the provisions in this bill. And then the provisions will rise or fall on their own merits. And I have to say, the same problem comes up when the references to the MRRA. And I corrected the record on this last time this came up as well, and I will do it again. The Minnesota Rehabilitation and Reinvestment Act. And the broad brush here was that I talked to constituents where I live, and I said, do you want to do anything that's going to reduce sentences for criminals? And they said no, and well, then we can't do it. But that's not what the MRRA does. So let's at least be honest about what it does, and then we can have an open conversation on the merits of it. What it does is it creates an individualized rehabilitation plan for the people who go to prison. So they have a robust assessment and they set concrete, personalized rehabilitation goals. And then if they engage in the program and successfully complete it, they earn their reduction in sentence and how long they stay in prison. They earn it. You give them an incentive, you get positive behavior, they get rewarded by reducing the time they spend. And same with their supervision upon release. Set up specific goals, a program, they comply with it, an incentive, they get rewarded by reduced parole time or supervision time. And then the savings that result from that reduced prison time in particular, that gets reinvested in victim support services, crime prevention intervention initiatives, and community-based correctional programs, i.e. probation. That's what it does. And so I'm willing to bet that if you explained all of that to your constituents, then they'd be a lot more willing to say, well, that sounds like a pretty good program. We've got the same description regarding probation. Yes, they need more resources. We've been pounding the table for more resources for a long time for probation. But it doesn't do any good to say they need more resources to supervise the first-time offenders that are out there. Some of them, of course, but where their real need, where the real resource shortage is in the high-level, high-need offenders. Those are the tough ones. They take up 80% of our probation officers' time. And so this majority has controlled the funding for the probation departments for the last 6 years. It's good that we're making strides now to fill in the deficiencies that we have created, or that has been created here. And one other thing that's worth noting is that again, broad brush, reference to the probation cap by the Sentencing Guidelines Commission. It was not a hard cap. And if you're going to be honest about the proposal, so we can have an honest discussion here, it was not a hard cap. It was a presumptive cap that was proposed at 5 years with exceptions, with departures that could be imposed by the sentencing judge if certain criteria were met. So there are people who have legitimate disagreements about whether that's the right way to approach things. But at least let's have the conversation based on the actual facts of the proposals and not on some broad brush inaccurate information. Now, Mr. Chairman, I'm going to try to be brief because I know there are others probably want to have something to say. But there are a couple of questions I had about the bill that's before us specifically. One is on page 27, having to do with Article 2, Section 5. This, I believe, was the adjustment, putting into statutes and sentencing criteria for the murder of an unborn child. And my question has to do with maybe the definitions here, and I'll just admit to my own ignorance with regard to this particular provision. Does it apply? At what point in the term of the pregnancy does it become effective? Does the state have to prove that the offender knew that the woman was pregnant at the time of the assault that created the death of the unborn child? And does the offender need to have intended to kill the child, the unborn child? Those are my questions, and in particular because there is one of these provisions that addresses a life sentence.
Mr. Backus, would you be willing to take that?
Mr. Chair, members, I'm trying to catch up with the questions. So if you look at 609.2661, that's the murder of the unborn child in the first degree, which this applies to. It applies to whoever does any of the following, is guilty of murder of an unborn child in the first degree and must be sentenced to life imprisonment. That's current law, life imprisonment. Causes the death of an unborn child with premeditation and intent to effect the death of the unborn child or another, or causes the death of an unborn child while committing or attempting to commit essentially a violent criminal sexual conduct offense upon the mother, or causes the death of an unborn child with intent to effect the death of the unborn child or another while committing or attempted to commit certain felony cases. Unborn child is defined as the unborn offspring of a human being conceived but not yet born, and whoever is defined as to not include the pregnant woman. So a pregnant woman cannot be convicted of murder of an unborn child.
So,
Senator Latz.
thank you, Mr. Chairman. So I'm going to, without reading through all the rest of those provisions, it sounds like for purposes of these sentences, it treats the unborn child as a person for purposes of determining intent and the target of the offender. So to me, that makes good sense, and I have no problem at all with the provisions that are here. I know the Guidelines Commission requested the clarity on this, so thank you for that information. On, I do appreciate on page 35 that the author included a provision, it was page 35, that allowed for sentencing beneath mandatory minimums where dealing with accomplices who were not aware that the defendant's accomplice had a gun or firearm in their possession. I appreciate narrowing this down to firearms and not just the very unwieldy definition of just any dangerous weapon which was presented as one of the options. I think this is a more reasonable approach if one agrees with the concept of mandatory minimum sentences, which, as the committee knows, I don't. But one area I wish we can take a look at between now and Wednesday, when it's expected that we'll take up this bill on the merits for a decision anyway. If you look on line 36.9, where the motion is for a non-mandatory
What
minimum
page, Senator
sentence.
Lance?
Mr. Senator Limmer?
What page?
36 page, Senator Limmer, line 9, where you're disqualified from bringing a motion for a less than mandatory minimum sentence if there was a firearm within immediate reach. And it just seems to me there's still an unfairness that could happen if there's an accomplice who's sitting in the car and there's a firearm in a glove compartment that they don't know about but would be within their immediate reach. And there's no room there then for a judge.
Senator
for
Latz, on that paragraph D, that's where you're at?
Yes.
36.9. Mr. Backus, is that the current law, and this is just a restatement of that? Or is this change in there?
Mr. Chair and members, that is current law. If you look at 609.11 subdivision 8, paragraph C, and I think if you look on lines 35.10 to 35.15, it's being stricken there and being essentially moved here. Because that subdivision where it's being stricken in the bill is now dedicated specifically to dangerous weapons cases and not felony case, and not firearm cases.
Thank you. Senator Latz, I'm sorry.
Well, perhaps I've found a problem with current statute, but it's still something that needs to be addressed.
Very good.
It's only an issue if there's a mandatory minimum sentence that's imposed here. If there's no mandatory minimum, then the judge has the discretion to factor in, how proximate the firearm is to the defendant. I also want to note on page 43 that relating to enhanced penalties, we still have extraordinarily long list of crime of violence. I went through a number of those items last time where I thought the list was overly broad, but still restrains the sentencing judge from accounting for differences in those things. It's another problem with this kind of mandatory sentencing provisions. So, Mr. Chairman, there are other things. Obviously, I appreciate some of the provisions in here that will help retain law enforcement, which I think we need to do. I think one of the reasons that we have this problem was created by some members of law enforcement in the first place, and I've got a little bit of hesitation in rewarding them, or rewarding some of them for that situation, but we do need to have enough officers on the street to solve crimes and to prevent crimes as well, and I think that's important to do. But if we had a better balanced bill, I think we'd find a broader bipartisan support for it, and I just don't see that here right now. Thank you, Mr. Chairman.
Thank you, Senator Latz. And I see the marquee section 14 of this bill is that removal of the $8 fee. I think that's a Senator Latz bill.
That alone,
That should get the vote right there.
that should be enough for the vote. But I'll note that was also Senator Matthew's bill.
Very good. Senator Kiffmeyer.
We're together on that.
Sarah Kiffmeyer.
Thank you, Mr. Chair. I really appreciate the bill that Senator Limmer has put together here. It's thoughtful. Probably the most important thing is that it's focused on results and about our people of Minnesota, their needs that we hear about. I was kind of surprised today, and I've heard this once before, that somehow anecdotes aren't valid. They're dismissed, that they're just anecdotes. Really? When I think of my constituents telling about their experiences, I don't know, I think that's pretty valid. I wouldn't want to dismiss their comments and their experiences. I think of the real victims who tell their story, I guess you could call them anecdotes, that they're talking about their hurts, their harms, the children, the carjackings, the things we see on the news all the time, that somehow that's not real enough. I don't agree with that. I think people, our constituents and others who tell us about their real-life experiences, we don't need a Harvard study to validify their real-life experience. These are things that are important and are real. And Senator Limmer, I have some other questions that I think I'd like to do, but I see that our committee time has ended, and I know we all have many meetings, so we can pick this up again at the next hearing. But the most important thing is the evidence that's right in front of us. Our constituents, our people of Minnesota, and I know, Senator Limmer, that's who you've listened to, that's who you've responded to. Hearing them, the victims and other people that we have today, and that evidence is very valid for us in what we do here today. Hearing them, listening to them, responding to their voices and what they are experiencing, that it's real and it's valid and we won't dismiss it, and that will bring forth legislation, as you have here, Senator Limmer, that demonstrates your care and your concern for these victims and for other people, and the ones that we've had sitting right where you are, Senator Limmer, telling of their real-life experiences. Those things matter. And the bill that you have here today is a response to that. You've heard them, you've listened to them, and you've brought forward, and several of our members have brought forward things that show that we're listening and responding to them, even including the public defenders. It's important, we want to make sure that that is included as well, that they have a best defense, that we can publicly pay for them. And then some other things that are in here very well. Community Corrections Act, doing a lot of good work there. The Adult Offender Transportation. So it's a well-balanced bill that takes many parts of the judicial system, from the courts to the defenders to the prosecutors, most importantly being a voice for the victims and for those who are concerned about their public safety. So I do have a few other questions about Senator Limmer. Thank you for this bill. It's good to know. I can tell the folks in my district that they've been listened to and that their concerns are validated in your bill here today. Thank you, Mr. Chair.
Thank you, Senator Kiffmeyer. We are up against the time here, however, we do have a few minutes. Senator Bingham, would you like to?
Yeah, thank you, Mr. Chair.
Final comments?
You know, I think when we're looking at our communities right now, I think we need to focus on reducing crime today so we can prevent crime tomorrow. That should be our goal. That should be our focus. And I think there are a lot of good, in my opinion, a lot of good things in this bill. I think you look at the county portion where the supervision occurs is a big win for Minnesota and for counties and for property taxpayers. And I appreciate that being in here. I think you look at the public defender and some of the other programming that are in here really helps take a broad approach to things, but I'm just wondering when I see the sentencing guideline stuff, except for Senator Matthews' bill, which I think is fantastic about recording the meetings and that I think that's a very good thing for transparency. I'm thinking about what can reduce crime today to prevent crime tomorrow. And I hope that as we're going through this process, we keep a focus on that, because I think the bill could use some tweaking, and I'm sure that's what Wednesday's for, right, Mr. Chair? To have a broader discussion and hear testimony from folks on this. Because I do think there are items in here that would have broad bipartisan support, but I also think there are items in here that I don't know that get at our overall goal of reducing crime today so that people, feel safer in the communities no matter where they live. And also look at preventing crime tomorrow, getting on the front end of it with YIPA money, which that's a little bit underfunded for what I think it should be, and some of the other community funding that should be in there to help tackle this. But, I may come at this from a different approach just because of my local experience, local government experience. But I'm happy to see spot shotter in the helicopter funding. I think those are things that we'll look at how we can gather some of that data and also keep some of our community our communities safe. But I do think we have to look at getting ahead of this and preventing the crime. And so let's hopefully work as we go through this week. With that in mind, members, that's what I ask, is let's take a look at reducing crime today so that we can prevent it tomorrow.
Thank you. I've got Senator Matthews on there. Did you want to make a quick follow-up?
Well, just
Sorry,
wondering
Lance.
what the process is going to be for this week and if anything for next week as well.
I'll go over that here right when we're closing up.
Thank you.
Senator Matthews? No? Okay. Senator Limmer, would you like any closing comments before we go on to the rest of the week here process?
Thank you, Mr. Chairman. As usual, we've had a very good discussion. We're just starting the discussion this week with this bill. Gives us a little bit of a starting point. As we look at it, there's been a number of good things said by all of our members. I hope we can come to a final agreement at the end of the week, but nevertheless, I think it's vitally important to give a signal to the people of Minnesota that are being victimized. They see the threats in the daily news. We need to respond. And I'm not necessarily thinking that levels of bureaucracy are going to solve the problem on the streets. We need to reinforce our law enforcement. We need to show a response to the public that this lawlessness that is currently in our society needs to be curtailed, and it needs to be curtailed as quickly as possible. That's been the focus of my attention in the last few years. This crime problem started, you can track it, it started way before the death of George Floyd, and it's been growing ever since. And so I've also heard the polling, even in areas like North Minneapolis, where 80% of the citizens there, by a Star Tribune report, or a poll, has shown that 80% want more law enforcement. And of course, they want more responsible, accountable law enforcement. And I don't think we can shy away from that responsibility and that charge. So I look forward to the discussion as we build the bill, and we'll go from there.
Thank you,
Thank you
Senator
for your
Limmer.
time, everyone.
Appreciate that. So going forward on Wednesday, when we meet, we're going to take public testimony on the provisions of this bill. And then clear your schedules, because Friday we'll be back here to do committee work and take the vote. Any questions?
So, Mr. Chairman, we should expect opportunities for amendments and a final vote on this bill would occur Friday?
That's correct.
Okay. And is there any plan, I know we've got the, Friday is the second deadline for bills. Is there any plan for any committee activity the following week prior to the third deadline, which is the budget deadline?
Not at this time.
Okay.
That's the official note that I got, so not at this time.
So we should
We'll
anticipate.
keep you up to date towards the end.
Thank you,
Next
Mr. Chairman.
this
So I
week.
guess the message for those of us who may be considering amendments is, this is going to be the last train out of the station, and it'll happen on Friday. And we should not anticipate any, we should not plan on any further committee action to move policy proposals after that.
That's correct.
Thank you, Mr. Chairman.
Thank you, Senator Latz. All right, with that, no further business being before the committee, we are adjourned.